Bailey Willet was born in April of 1999 and grew up in suburban Melbourne. He had a largely unremarkable childhood, growing up with his parents and siblings while attending school and playing sport. He completed Year 12 and commenced a plumbing apprenticeship before moving into concreting. Bailey is a talented sportsman and has excelled in the sport of hockey. Before this offending, he'd not been in trouble with the law. He's a hard worker and is well liked by work colleagues and other members of the community, as is apparent by the remarkable support he has in court today. Mr and Mrs Willet separated when Bailey was 15, and this led to a period of financial hardship. Bailey's mother, Sarah, tells the court that at this time, Bailey became constantly worried about money. He also developed a taste for the lifestyle that money can buy. In his early 20s, like a lot of young people, Bailey Willet experimented with drugs. By the age of 24, Mr Willet had been introduced to a drug syndicate. He was immediately impressed by the material possessions that his new friends had. As his lawyers have told the court, instead of working hard, Bailey succumbed to the allure of fast money and began performing tasks for the syndicate. This led to his involvement in large-scale drug importation and trafficking, as well as money laundering. The drugs that Mr Willet attempted to import and trafficked cause untold damage to people in our community, as this court sees on a daily basis. Today, Bailey Willet will be sentenced to a lengthy jail sentence for his crimes. He's still only 27 and will spend what should be the best years of his life in custody. The simple message for any young person who's tempted to make large amounts of easy money by drug trafficking is don't. You run a high risk of being caught, and when you're caught, you too will go to jail for a long time. Bailey Jack Willet, you've pleaded guilty to a charge of attempting to import a commercial quantity of a border-controlled drug, methamphetamine, contrary to sections 11.1 and 307.1 of the Criminal Code, which carries a maximum penalty of life imprisonment, and a charge of trafficking in a large commercial quantity of a drug of dependence, a rolled-up count, contrary to section 71 of the Drugs, Poisons and Controlled Substances Act 1981, Victoria, which carries a maximum penalty of life imprisonment. The standard sentence is 16 years imprisonment. You've also admitted guilt with respect to two scheduled offences: a charge of dealing in proceeds of crime in an amount more than $100,000, believing it to be proceeds of crime, contrary to section 400.4 of the Criminal Code, which carries a maximum penalty of 20 years imprisonment, and a charge of trafficking in a drug of dependence, MDMA, contrary to section 71AC of the Drugs, Poisons and Controlled Substances Act 1981, which carries a maximum penalty of 15 years imprisonment. You've agreed that these offences can be taken into account by the court in passing sentence on you in respect to the offences of which you have been convicted. You are to be sentenced on the basis of the summary of prosecution opening for plea dated the 22nd of May 2026, which I note is an agreed document. I'll start with the circumstances of the offending, which are very detailed. By way of background, you are aged between 23 and 25 during the offending period. You had employment as a concreter, but were not employed in this role full time. You lived with a housemate, Jordan Montalto, who I'll refer to as Montalto, at an address in Werribee for at least part of the offending period. Montalto has not been charged with any offending. You acted at the behest of a known associate to import drugs of dependence, traffic drugs of dependence, and deposit and receive significant sums of cash on behalf of a criminal syndicate. You communicated directly with one person on encrypted messaging applications who directed you to perform tasks as required. Messages reveal that that person was likely offshore. He's referred to as the offshore facilitator. As such, you were the onshore coordinator for the importation and other trafficking activity on behalf of the syndicate in Melbourne. There is no evidence you were assisted by other persons when completing any of the tasks as directed. You were paid an hourly wage for your work and would report your hours to the offshore facilitator. You were also paid additional amounts for expenses you incurred, such as travel, fuel and equipment. In addition to the tasks set by the syndicate, you engaged in your own smaller business of selling ketamine and MDMA for personal profit. Starting with charge 1, attempting to import a commercial quantity of a border-controlled drug between 8 November 2023 and 16 November 2023. On 6 November 2023, a consignment arrived in Australia via Qantas Freight from Guadalajara, Mexico. The consignment landed in Sydney and was transported under bond to Melbourne. The consignment bore the following details. Consignee, Redline Engineering, 309 Boundary Road, Mordialloc, then with some email addresses. The consignment was described as containing an automatic component inspection machine weighing 1,013 kilograms. Redline Engineering is a legitimate Australian business based in Mordialloc. Redline Engineering was not involved in the importation of the consignment. Rather, the details of this legitimate company were used in a process known as piggybacking, whereby a criminal organisation utilises the business details of legitimate businesses with valid importation histories to attempt to avoid customs inspections on arrival into Australia. On the 8th of November 2023, on arrival into Melbourne, the consignment was subjected to customs inspection by the Australian Border Force, ABF. The consignment underwent X-ray scanning, which showed anomalies. The consignment was then subjected to a physical examination. In a rectangular steel compartment built within the consignment, ABF officers located a black metal box. Inside that metal box was another metal box wrapped with tape. Inside that was a black plastic box containing a loose white crystalline substance. The substance was further analysed and found to contain 78.98 kilograms of methamphetamine with a purity of 80.3%. The total pure amount of methamphetamine is calculated as 63.42 kilograms. This is 84.56 times the commercial quantity. The methamphetamine was removed from the consignment. Also on the 8th of November 2023, you purchased and activated a mobile phone with a number ending in 834, which I'll refer to as the consignment phone, subscribed in the false name of Den Choi of 33 King Street. On the same date, at around 3:05 p.m, you engaged in a conversation with your then housemate, Montalto, on a Google Pixel 7a encrypted device, which I'll refer to as the Google 7a phone, using the encrypted messaging application Threema. This will be referred to as the Threema chat. In that conversation, you told Montalto, I might make 50k this week, basically a shipment coming in, I DK what it is, but anyway, I went and got a phone from old mate in Chinatown and basically I need to call up this place and act as Luke the foreman boss. You told Montalto that another two blokes who you didn't know would then go and pick up the truck with the shit and that I was paid the worst but doesn't go anywhere near it. When asked whether it was risky, you responded that you had to speak on the burner somewhere secret and that you couldn't talk on the phone in your house in case the police traced the phone. You said that it was happening today or tomorrow. You later confirmed with Montalto that you wouldn't be in contact with the shipment at all. Montalto told you that you should go somewhere secure on the other side of the city with no cameras to make phone calls. You suggested somewhere like Cobbledick. Montalto told you not to say the name of the place just in case, and went on to describe a beach location he'd been to before. You told Montalto the other guys get like 200k, but they have to put the truck in their name and go pick it up. At 4:34 p.m. on the same day, still using the Threema messaging application, you explained to Montalto how you would assist in clearing the consignment. You told him the following: I'm an engineer, supposedly, my acting skills gonna need work. Tomorrow I'm calling a forwarding transport company that clears shipments from overseas. He's giving me a script with a name, etc., all on a cash phone, so yeah, I'm all good. Then I'll give them an email, but they will be talking to old mate on email, not me. When an engineer talks, how do they talk? Like, do they, hello, this from Redline Engineering, I'm just calling to see if your company can assist us with the freight forwarding to release our goods. Montalto asked, and you reckon you're going to get 50 big ones for that? You responded, that's what he said, and clarified that it's still a risk. You said you were being paid $50,000 because I've helped him out so much, blah, blah, and you have the easiest job out of everyone. Later that evening, you told Montalto that you were calling the following day at 9 a.m, but were waiting on information, like his name and shit. You asked Montalto whether he'd spoken to freight people before. On 9 November 2023, using the consignment phone, you contacted Global Freight Services, a freight forwarding business, and engaged them to assist to clear the consignment and arrange delivery. You spoke with Paul Gardner, the owner of Global Freight, and introduced yourself as Brendan White from Redline Engineering. At 10:22 a.m. on the same day, you contacted Montalto on the Threema chat. You told Montalto what had occurred that day, including that you said you were Brendan from Redline Engineering and that Gardner had told you to email him the details relating to the consignment. You said you were legit done unless Gardner called for something else, but you assumed Gardner would email rather than call. Montalto then asked whether old mate was going to email him, to which you responded, yeah. You confirmed that your role in the process was still risky because police could trace the number and then the phone, but you were confident they wouldn't. You said that is why you are in the bush right now and that you turned the consignment phone off. You also said you hadn't brought your personal phone with you. Montalto asked whether you were still getting 50G. You responded that your job was now done and that these other boys have to do their part, including picking it up. At 1:26 p.m, Global Freight received an email from an address at op manager at Redline Engineering, which attached relevant documentation for customs clearance and delivery, including the airway bill, pro forma invoice, and technical data of the component inspection machine. The email signature contained the consignment phone number as the relevant contact number for Brendan White, who purported to be the operations manager for Redline Engineering. Gardner subsequently processed the customs clearance. You continued to liaise with Gardner from Global Freight in relation to the delivery of the consignment and payment of associated fees, including by phone calls and text messages. On 13 November 2023, Gardner texted the consignment phone number and told you that Qantas would start charging storage fees at $800 a day. He asked you to call him back. He further told you that he'd sent you an email and required you to respond ASAP. At 10:47am, you told Montalto, using the Threema chat, that you think you have done it and the invoices were being sent now. You told Montalto that delivery should be tomorrow. On 14 November 2023, Gardner sent further text messages to you on the consignment phone requesting payment of an invoice totalling $10,974, import duties, storage fees and delivery costs, and told you if it was paid that day, the consignment could be delivered the following day. Using the consignment phone, you asked Gardner to send the invoice through to you and asked whether he also needed the LOA. You made further inquiries as to how the invoice could be paid. On 15 November 2023 at 9:30am, Gardner sent you a text message on the consignment phone inquiring about the progress of the payment of the invoice. At 11:06am, you told him you would have it done by lunchtime. Gardner told you that delivery was unlikely to happen today given the notice was yet to be paid. At 11:50am, you were observed by AFP surveillance at Cobbledick Streamside Reserve. At 12:10pm, you sent a message to Montalto on the Threema chat, told him your pay had been bumped to 60, so 66,400 ATM. Montalto asked whether they had picked it up and you responded not yet, but that payment was happening as we speak. At 1:04pm, you told Montalto that the payment had just been sent and was clearing now and that delivery would be tomorrow. You told Montalto, old mate has connections, let me tell you what. At 1:37pm, you messaged Gardner on the consignment phone and told him the invoice was paid and that you would email the receipt within the next hour. Gardner confirmed that delivery would occur the following day. You screenshotted this message and sent it to Montalto using the Threema chat. At 6:29pm, an email was sent from op manager at redlineengineering.com attaching the receipt for the invoice and requesting the time for delivery the following day. The invoice had been paid via a Wise Money transfer from Denpasar, Indonesia. Using the consignment phone, you sent a text message to Gardner apologising for the slow email and requesting confirmation of time for delivery. On 16 November 2023 at 7:54am, you left your house in Werribee and travelled in your housemate Suzuki to President's Park in Werribee. You were observed utilising your mobile phone device and remained at the park until 9:37am. At 9:45am, you called Gardner on the consignment phone. You again purported to be Brendan White. Gardner asked for the unit number at the delivery address of 309 Boundary Road as you were trying to book a time for delivery with the transport company. He told you he would book a time for delivery that afternoon. In text messages later that day, you confirmed there was no unit number and that they would be there with forklifts. Gardner told you he tried to book the delivery, but there were about 10 units in the block and he needed the unit number for delivery. When you couldn't give him the unit number, Gardner told you to text the address to him. You sent Gardner a text message on the consignment phone clarifying the address as 6309 Boundary Road. Gardner said he would organise a delivery time. You told Gardner to give the consignment phone number to the delivery driver in the event he needed assistance. At 11:24 a.m, you sent a message to Gardner using the consignment phone, requesting an ETA for delivery. Gardner confirmed around 3 p.m. You told Gardner to update me on any changes of time so I can make sure someone is there and ready. At 2:24 p.m, Gardner called you on the consignment phone and told you the consignment was on its way and should arrive between 3 and 3:30 p.m. Gardner told you to send him a text message once you'd received it. During the course of the morning and early afternoon, you travelled back to your address in Werribee and then to Westfield Southland in Cheltenham. At 1:13 p.m, you travelled to Mordialloc and continued to travel around Mordialloc until 3:09 p.m, when you drove to 286 Boundary Road, Braeside. This address is directly opposite the consignment delivery address. At 3:46 p.m, a pallet was observed being delivered by direct couriers to 1309 Boundary Road. From 3:46 p.m, AFP surveillance observed a wooden pallet situated out the front of Unit 1 and a forklift attempting to move the pallet. You remained in your vehicle observing. At 4 p.m, you contacted Montalto on the Threema chat and told him you were a spy, RM. You sent him an image of the pallet outside Unit 1 and told him that was the delivery. At 4:06 p.m, you sent a message to Gardner using the consignment phone and confirmed the consignment had been delivered. You then turned off the consignment phone. You continued to message Montalto on the Threema chat. At 4:14 p.m, you told Montalto the consignment had been delivered and that you were watching them move it into the warehouse. You confirmed you were conducting surveillance to make sure it goes in there, and that you were told to take precautions to make sure they don't run off with it. You confirmed your payment had increased to $70,000, but that you wouldn't have it for a few weeks because they had to move it all first. Using the Google 7A phone, you also messaged a person known as Spider using the Threema application and sent him a photo of the consignment on the forklift. You said you were like a secret agent watching and that you had been driving around all day, but you hoped it was worth it. At 5:56 p.m, the consignment was secured inside Unit 1, 309 Boundary Road, Mordialloc. At 6:30 p.m, you left Boundary Road and drove in the direction of your address in Werribee. At around 7:35 p.m, you made a stop in Parkland and disposed of the consignment phone in the Werribee River. At around 7:42 p.m, you became concerned that you were being followed by police. In a message using the Molly encrypted application on your Google 7A phone, you told a contact identified as Chewy that you had observed vehicles parked near your house and so did not return home. Chewy responded with undercover in reference to undercover police. Based on other messages which are discussed below, Chewy is the handle name for the offshore contact directing you in respect of the importation and trafficking of border-controlled drugs. At around 8:05 p.m, you continued to a set of shops on Grieve Street, Werribee, where you had a further conversation with Spider. You told him you were to be paid $65,000, but the total would be $71,000, and you just needed to wait until the consignment was unpacked and moved to be paid. At 8:10 p.m, you were arrested at Quartock Avenue, Werribee, within a minute drive from your home address. The Google 7A phone was located on you at the time of your arrest. You provided the PIN code to this phone. You also told police you had another phone, but that it had been disposed of in the Werribee River. You took police to the location where the phone was said to have been disposed of in the Werribee River. The phone was not recovered. Police accessed the Google 7A phone using the PIN code and made a limited number of recordings of communications between you and others, as well as the search history. The device lost connectivity to the internet, which triggered a factory reset. All data was wiped from the phone. This was an inbuilt security feature of the phone. Police executed a search warrant at your home. They seized an Apple iPhone belonging to Montalto. In your bedroom, police located a further Google Pixel 5 phone and an Apple iPhone Pro Max belonging to you. Investigators were able to obtain the communications between you and Montalto on the Threema chat from Montalto's device. You were interviewed at 11:22 p.m. at the AFP Melbourne headquarters. You told police you wished to exercise your right to make a no-comment interview. Despite that, you subsequently made the following relevant comments. A, that you had a phone that you wanted to get rid of, so you threw it in the river. You couldn't remember who gave the phone to you or how long you had the phone for. B, you were driving your housemate's car, which you used instead of your own because it's cheaper. C, your personal belongings would be found in your bedroom. D, you denied that anything found in the fridge would belong to you, but you weren't sure if the Pyrex containers with amphetamine remnants would show your DNA. E, you gave a no comment interview with respect to further questions put to you about conversations located on your Google 7A phone. You told police you didn't know anything about a shipment and did not know who Brendan White was. On further examination of the Google 7A phone, police located internet search history from 11 November 2023, which showed that you'd conducted searches relating to global freight companies in Melbourne, Redline Engineering, including Brendan White at Redline Engineering. The Google 7A phone was also connected to an international SIM. On execution of the warrant, police also located items you had used to manufacture drugs and to traffic drugs at the house, and these included, in your bedroom, small clear seal clip bag containing ketamine and cocaine, small clip seal bag containing 0.6 grams of ketamine, which is 0.3 grams pure, 5 small clip seal bags, swabs confirmed the existence of cocaine and ketamine, paper envelope containing 3.1 grams of pure ketamine, two digital scales with white residue. In the kitchen, a clip seal bag containing 0.38 grams of LSD, which is less than 0.01 grams pure. In the garage, 5 glass Pyrex dishes located in the garage fridge. Swabs confirmed the existence of methamphetamine and MDMA. Turning to charge 2, trafficking in a large commercial quantity of a drug of dependence between 27 December 2022 and 28 September 2023. Police accessed your Pixel 5 phone and your Apple iPhone. These phones revealed significant drug trafficking activity between you and others using the encrypted Signal and Threema messaging applications. In summary, the messages reveal that you were tasked to traffic in 4 different drugs of dependence by the offshore facilitator who controlled the syndicate. You engaged in trafficking activities by collecting drugs, selling drugs, collecting consignments of drugs, and manufacturing drugs. You also attended at a warehouse on behalf of the syndicate where money and drugs were kept and were aware of the access codes for entry. You also completed various other tasks, including collecting vehicles, collecting equipment, including prepaid SIMs, and meeting with other associates on behalf of the syndicate. You were also tasked to deliver and collect significant sums of money in cash on behalf of the offshore facilitator. This was a distinct activity from the sale of drugs. In total, you dealt with $820,500 between 2 March 2023 and 27 September 2023. You were paid for your work at the rate of $200 an hour by the offshore facilitator. Messages reveal that you also manufactured drugs on behalf of the syndicate and received $2,000 for each substance manufactured. You were instructed to deduct your pay from cash you had in your possession as a result of previous trafficking activities undertaken by the syndicate. You were also reimbursed for all out-of-pocket expenses. As set out below, you communicated with different handles on the encrypted messaging applications. For example, Wally Lewis, President Richard Nixon, Warwick Capper, Indiana Jones, Vinnie Jones, Mick Dundee and Chubby. The messages reveal the user of these handles was the same person, namely the offshore facilitator of the syndicate. You also communicated with the user Ray Finkel, Rambo and Poitier. The messages reveal the use of those handles was the same person. That person was known to you and the offshore facilitator. He provided drugs in wholesale amounts for on-selling by you for your own personal drug business, as well as by you and the offshore facilitator with respect to the larger enterprise. In total, you trafficked the following amounts in a large commercial quantity. A, ketamine in the amount of at least 2.12 kilograms between 27 December 2022 and 12 April 2023, which is a little over twice the large commercial quantity. MDMA in the amount of 6.13 kilograms between 29 August 2023 and 25 September 2023, a little over 6 times the large commercial quantity. Methamphetamine in the amount of 9.78 kilograms between 30 August 2023 and 21 September 2023, a little over 13 times the large commercial quantity. And cocaine in the amount of 5 kilograms between 12 September and 28 September 2023, which is 5 times the large commercial quantity. The charge is based on the mixed quantities only, given no drugs were seized or located, such as to determine their purity. Starting with the ketamine, in addition to trafficking on behalf of the offshore facilitator, you sold in smaller amounts to individual buyers known to you. You purchased ketamine from the offshore facilitator, collected it from a third party and on-sold it for personal profit. On 18 November 2022, you sold 3 grams of ketamine to Kobe Spiteri for and that's an uncharged act as part of context. On 27 December 2022, you received in the mail 2 bottles labelled Uno Pure Ultra Finishing containing ketamine. Wally Lewis, WL, asked you to send him a video of the package and told you to separate it. You unpackaged the ketamine and put it in 5 tubs to dry out. The bottles of Uno Pure had the capacity to contain 1 litre of the substance. This charge is put on the basis that you possessed at least 1 litre of ketamine. You performed the task of processing the ketamine by removing and separating it from the packages. You said you would then take it to the warehouse the following morning. Transaction 2. On 29 December 2022, WL asked you for payment with respect to 10 ounces of ketamine you'd previously purchased from him at a cost of $22,000. You confirmed you owed WL $36,200. This included a purchase of MDMA discussed below and would drop the money to Rambo. The payment to Rambo is discussed below with respect to proceeds of crime charge. On 6 January 2023, WL queried whether you had paid Rambo for the ketamine and MDMA. WL asked you if you needed more ketamine. You said you were waiting for people to pay you before giving them more. On 10 February 2023, WL asked if you needed more ketamine. You said you would ask around but guessed you wanted more. WL told you he would give it to you cheaper, but that you should drop your prices so that word would get out. WL suggested $1,900 an ounce. On 12 February 2023, you confirmed you wanted 10 ounces. You asked if it was the same stuff as last time, and WL told you it was top quality. You confirmed you would pay what was owed to Rambo. On 15 February 2023, you began on-selling the ketamine as part of your personal business. On 19 February 2023, Gary requested 3 to 4 ounces of ketamine from you. The two of you agreed to meet on 21 February 2023 for the sale. Gary confirmed he had $4,300 as payment owed for a previous sale of ketamine but wanted another 3 ounces. You told him an additional gram when the two of you met. Total 141 grams sale. On 20 February 2023, you purchased another 10 ounces of ketamine from WL. You confirmed in a later conversation with Dino's that it was good stuff. WL said he would sort out with Rambo for you to collect. From 21 February 2023, you on-sold this bulk amount of ketamine as part of your personal business. You made the following sales. 21 February 2023, 1 ounce ketamine to Dino's. Same date, 2 ounces of ketamine to Stacker 88. Same date, 1 ounce of ketamine to Kobe. On the following date, 1 ounce and a further 7 grams to Terence M for $3,000. On 24 February, 2 ounces of ketamine to Kobe for $4,600. On the 1st of March 2023, 2 ounces of ketamine to Terence M for $4,600, and the same transaction on the 2nd of March 2023, totalling 315 grams in sales. On 10 April 2023, Richard Nixon told you he had some good horse. He asked you if you're still interested in working and cooking. You said you could help here and there as you're about to start a full-time job. Between 11 and 12 April 2023, you purchased 10 ounces of ketamine from RN at $2,000 an ounce. RN asked you how your sales were going, and you said people liked it more than last time and that you only had 2 ounces left after the long weekend. You said you would need more soon. RN told you that he had parcels arriving next week. On 11 April 2023, in a conversation with Ligma Balls, you offered to sell half an ounce of ketamine for $1,500. On 21 April 2023, you told LB that an ounce was $2,400 and that you just picked up yesterday. LB said he would keep it in mind. You had a similar conversation with Terence M on 11 April 2023, where you told him you had Crystal K for $2,400 an ounce. Terence M purchased an ounce and a further 3 grams from you for $2,600. You also gave him a tester and said it was meant to be better than last time. You sold the following amounts of ketamine as part of your personal business from 15 July 2023. On 15 July, 6 grams of ketamine to Saxon. On 27 September 2023, an ounce of ketamine to Boggy for $1,800. Boggy paid you a further $2,500 for a previous drug transaction. On 27 September 2023, you sold 7 Spider 7 that you told 7 Spider 7 that you sold ketamine easily and would have 4 to 5 ounces at any time. Turning to the MDMA schedule offence. On 29 December 2022, you requested a bill from WL for 10 ounces of MDMA and 10 ounces of ketamine you had previously purchased from him. You also told him you had completed 23 hours of work. WL confirmed 10 ounces of ketamine was $22,000 and 10 ounces of MDA was $1,900. You deducted the amounts owing to WL from your work hours. On 2 January 2023, WL followed up with you and asked you what was happening with the M money. You told him Rambo has all the money. On 25 January 2023, WL continued to ask about payment. You told him that you had his money, but you didn't have any of your own to pay WL as you were waiting on $20,000 that you were owed. You later confirmed that you would drop WL's money to Rambo. On 2 March 2023, WL asked you if you wanted any MDMA. You told him it would be $2,000 an ounce. You said you would grab 2. You asked whether there was any more K, to which WL responded more was coming. You then asked to use a Terence M if he wanted any MDMA and that you could sell it for $2,500 an ounce. Terence M told you he was interested in ketamine. On 19 July 2023, you were paid $1,500 for a sample of MDMA. You confirmed your hours so far was 16.5 and so you were owed $3,300. A further $2,000 was deducted from the amount you owed for ketamine. Between 29 August and 30 August 2023, you manufactured MDMA at your home address. On 29 August 2023, Vinnie Jones, VJ, asked you how the M was looking. You said it was nearly dry and it looked like there was about a kilogram, but it didn't look like as much as the other batch you pre-made. VJ told you there should have been 2 kilograms. VJ further told you that you just had to let it dry out because the last time they gave it to someone it was too wet. You later told VJ that you'd weighed the substance. It came to 1,623 grams. You then sent a picture of the substance. You said that you had 788 grams of black and 836 grams of champagne. VJ told you he would explain to you later how to crush it up. You trafficked the MDMA the following day under the direction of VJ. On 20 September 2023, you sent Chewy an image of 5 bags of a white substance. Chewy told you that it should be 4.5 and to stash it as it's heading out Monday. On 25 September 2023, Chewy told you to be at Caulfield at 6 p.m. to pass them the 4.5 kilograms of M. You responded that it wasn't M, and Chewy reminded you, remember the 4.5 kg and that it is white M and that he has tested it. On 30 August 2023 at 7:57 p.m, VJ directed you to drop off 1,533 grams shard in kilo, 3 keys or kilograms of shard and 1,620 grams of M in Caulfield. VJ directed you to go to Killer first and provided the address. He told you to make sure you gave him the right bag. You confirmed that it was done. VJ then provided you with the address in Caulfield. VJ told you there was a car leaving for interstate that evening. You said you felt unwell, but you would make it, and VJ told you you could add an extra hour for juice and sick pay. Later messages reveal you felt unwell as a result of having cooked methamphetamine at your house. You confirmed at 9:59 p.m. that it was done. VJ then tasked you with jobs for the following day, including getting cash off Big Man, get Box Tarneat, get PPE. VJ told you to send your hours for the day. You calculated your hours as 3 hours. On 31 August 2023, you and VJ discussed the manufacture of methamphetamine, which was currently in the fridge at your home address. You told VJ you were going to Bunnings to get proper equipment, including a respirator and gloves, which cost $100. You sent a photo of yourself in PPE, as well as photos of crushed crystal-like substance in a plastic container. VJ directed you as to how to contact the cooking process properly. VJ asked whether you're doing 1 kilogram at a time, to which you responded you put 2 in. VJ asked whether the substance looked like it did last time. You told VJ you'd spent 3 hours cooking. From 1 September, you continued to manufacture methamphetamine in accordance with directions from VJ. You sent VJ images of the substance so VJ could show them and describe to VJ what you were doing in terms of cooking the methamphetamine. On 1 September 2023, you weighed the first batch of shard and confirmed it weighed 87 grams. On 3 September 2023, VJ sent you a document of the re-sharding process, which you attempted to follow. On 4 September 2023, you collected several items for the process, including a thermometer, an induction cooker and an esky. VJ told you should manufacture it tonight, as they had a lot on over the next few days. You told VJ you'd spent 3.5 hours on the process and sent an image of the substance in the fridge. On 5 September 2023, VJ told you that they would have to sort out these two keys in the fridge. You kept VJ updated as to the state of the manufacturing process, including by sending further images of the shard between 8 and 11 September 2023. You followed instructions from VJ with respect to the recrystallisation process, and on 11 September 2023 confirmed you'd only one step left. On 11 September 2023, you confirmed the total hours for the shard was 6 hours, but there was equipment costs too. You'd previously asked for more money for cooking the methamphetamine at your house, and VJ told you it was $2K per batch. On 12 September 2023, you sent Chewy a document calculating the total number of hours worked, as well as money spent on flights to Sydney, Ubers, cooking and equipment. You calculated you'd worked 38 hours plus an additional 8.5 hours for a trip to Sydney. You also listed 2 times cooked product at an amount of $2,000 per product. Chewy confirmed you were owed $16,310. You asked whether they still had other work coming up this weekend or if you should look for something else. Chewy confirmed there was heaps of work. Messages confirm you travelled to Sydney the previous day at the behest of Chewy to discuss a location for possible manufacture of drugs of dependence. You confirmed you would now reset your phone to clear the contents. Chewy told you you needed to drop off some of the shard you had previously cooked. You confirmed you'd done it. On 31 August 2023, you sent VJ an image of a package. It was addressed to Bailey Brogg and an address in Wyndham Vale and had been shipped from the United States. The parcel weighed 2.63 kilograms. Inside were 2 packages containing a crystal substance. VJ told you it should be 2 kilograms and you confirmed it was. VJ told you he would be able to move it pretty fast and was trying to get someone for tomorrow. On 5 September 2023, VJ told you he needed to take those 2 keys to a bloke and to take $40,000 to his family at the same spot as usual. You would then need to do about 600K of transactions. VJ told you he needed to collect a drum of chems tomorrow, but he shouldn't worry because it wasn't illegal. He later told you he was still waiting on the bloke about the 2 keys. On 8 September 2023, VJ told you he needed to drop off a ket sample, that is ketamine, in Port Phillip and a cold drop of pseudo, that's pseudoephedrine, in exchange for methamphetamine that was supposed to be included in a cold drop of cash you'd collected the night before. VJ asked you what he could pass on the 2 keys and 187 grams loose back to these guys tomorrow, referring to the package of methamphetamine and the additional methamphetamine you'd collected. VJ told you to pass on the substance somewhere away from your house and do it somewhere discreet. You confirmed your hours that day as 7 hours. On 9 September 2023, you sent VJ an image of the package you'd earlier sent on 31 August 2023. VJ asked you to take out a small amount of the product to get a better picture. VJ told you to make sure you took all the shard there and confirmed that meant the 2 bags plus the leftover stuff handed back. You confirmed it was done. On 21 September 2023, Chewy asked you to contact FedEx and impersonate Ashley in relation to obtaining a package that had not been delivered. You contacted FedEx on a payphone. The place where you usually obtained a cash sim was closed. You were told the package was at the South Yarra Post Office. Chewy told you he was organising for others to collect the package, that you should attend an address in South Yarra to retrieve it. Chewy told you he needed pictures of the box and the substance, including the weight, so that he could send messages to move it on. You sent 3 images, including one of the package on a scale with the weight marked as 1.063 kilograms. You confirmed, I think, shard. On 6:49pm, Chewy told you he had somewhere to take the shard at 9 or 10pm that night. You confirmed at 9:07pm you'd completed the drop-off. On 22 September 2023, you sent your hours worked to Chewy. You calculated 27 hours, including 9 hours spent on chemicals, as well as additions for the truck, which cost $1,180 and equipment. Messages revealed that the drum of chemicals you were tasked to collect on 6 September 2023 was a drum of sulfuric acid. On 26 July 2023, you were directed by VJ to attend South Melbourne to meet Mr. Happy to collect a test of C. You were told it would be a 3-gram sample. This is in reference to a cocaine transaction. On 12 September 2023 at 8:20am, Chewy told you needed to pick up 2 bricks in South Melbourne and take them to Caulfield to the same spot. He told you that once collected, you were to go to Albert Park Golf Course to drop it off. Chewy directed you to a location in Albert Park. He told you his guy would be on foot and that his guy would place on passenger floor. At 1:08pm, you confirmed you'd arrived and had received the 2 bricks. On 17 September 2023, Chewy told you that his contacts in Sydney had enough C stored for a minimum of 1 year and that they just landed 600 bricks. Chewy told you our little team would take 300 to 600 per year and told you do the maths. He told you he was trying to set up an interstate driving and drop-off company that would be low risk and high reward for everyone and could amount to $30,000 to $60,000 per fortnight. You said you were interested because this isn't full sustainable for ages and you just wanted to save as much as you can so you can live comfortably. On 26 September 2023, you discussed with a contact named 7 Spider 7 the possibility of importing liquid cocaine. You said it was easy to make, but that importing it from overseas is the hardest part. You then discussed you could make $720,000 a year driving drugs between Melbourne and Sydney and Melbourne and Adelaide. You said you were paid $200 an hour for driving jobs within Melbourne. You discussed that 7 Spider 7 might be able to take on some of these jobs. On 27 September 2023, Chewy told you he needed help in the morning with the 3 brick pickups. You were told you had to pick up at 7am and drop off at 7:30am. You updated your total amount of hours worked, which was tallied at $10,020. The following day, Chewy told you to go to Burnley first and then to Richmond. At 7:34am, you told Chewy you'd arrived. Chewy told you that it would be placed on the back seat and to keep moving. You confirmed that you got it and were on your way to Caulfield. You later confirmed done. You and Chewy discussed the cost of cocaine on 29 September 2023. Chewy said a C brick was $145 and C loose was between $115 and $130. You responded that you knew heaps of people who wanted an ounce of C but were thinking of putting money together to buy a brick. Turning then to the dealing with money believed to be proceeds of crime. On 2 March 2023, you delivered $21,000 to Poitier. Poitier had previously asked you where his money was, and you told him that you were rounding it up and it shouldn't be long. Poitier's role for the offshore facilitator was to receive cash and supply controlled drugs on behalf of the offshore facilitator. On 29 March 2023, Poitier told you he needed to get a further $9,000 from you and asked you whether you also wanted any MDMA. That's a total of $21,000. On 13 July 2023, Indiana Jones told you he needed cash collected the following day. On 14 July 2023, you went to Essendon where you were told to give the recipient $80,000. You were told you had a further 2 by 20k drops in Sunshine, total of $120,000. On 15 July 2023, you told IJ, Indiana Jones, that you were now living on your own and so could do any cooking that needed to be done. IJ told you there was plenty of work and told you to extend your injury leave. He said he would have work for you 5 days a week. The following day, IJ tasked you with pickups of money, phones and samples. You completed the tasks and billed 6 hours for work undertaken. On 18 July 2023, you were told by IJ to get some money dropped off to people. You were told to take 2 bundles of $30,000 and deliver to Sunshine, the same spot as last time. There was an additional $15,000 you were to leave at your house. You confirmed you were using your burner phone with the VPN turned on, total $75,000. On 19 July 2023, you were directed to go to a phone shop, buy a cash SIM and then deliver $30,000 to someone. You were then to drop off a phone and a further $12,200. You confirmed at 5:37pm you dropped the cash and phone off, total $42,200. On 28 July 2023, VJ told you that all the money was ready to be collected that day and you would see Asian. VJ told you your new phone was ready and that you should pay for it out of the $52,000. Asian is a reference to a money launderer that you regularly deposited cash to in exchange for cryptocurrency. VJ told you that the money launderer charges 7 to 8% commission to convert cash to crypto. You made inquiries with VJ as to whether you could use the same process to convert your money so as to avoid detection. VJ explained to you how to conduct this process, including by downloading a special anonymous wallet. VJ told you it was not a good idea to have too much cash lying around. That's uncharged context. On 1 September 2023, VJ told you he needed to drop off and pick up cash that evening. Specifically, you were directed to collect $30,000 from the big man and another $35,000 from someone in Caulfield. You confirmed you'd completed the jobs and were told to stash the cash at your house. You provided your hours as 2.5 hours for tonight. That's uncharged context. On 6 September 2023, VJ directed you to collect a 1-tonne truck to collect a drum of chemicals and to drop $40,000 to his family at 7 p.m. VJ told you after you dropped the money you needed to give $7,000 to Asian from the $25,000 that was left over at your address and take the remaining $18,000 home as they needed to pay for some things tomorrow. You confirmed you'd deposited $40,000. You were then directed to attend Airport West, where you were to collect $123,000 in a dead drop. You confirmed that you'd collected $126,150 in an orange bag and would add the further $7,000. VJ told you to put $133,150 through the money counter. You sent VJ an image confirming that sum had been transferred in exchange for $78,670 in cryptocurrency. On 9 September 2023, you were directed by Chewy to collect $8,000 from money owed from a shop in Sunshine. You confirmed you'd attended and it was sorted. On 10 September 2023, you collected $8,000 in cash for VJ. On 11 September 2023, you were told to collect money at the usual spot in Caulfield. Chewy later asked whether you were at Asian. You confirmed you were and had counted the money. You had $48,950 from those guys. On 14 September 2023, you were tasked to collect $160,000 from Burwood and deliver it to a person in Richmond. You overslept and missed the initial time for the pickup, which meant the location needed to be changed. Chewy told you that you needed to be on point if you are going to commit to meetings. On 23 September 2023, you were tasked to deliver $80,500 to Asian. Chewy told you, out of that money, I need you to take $12,000 with you and get old mate to do the rest. You told him you would send the wallet address. You confirmed you were nearly there and to send when ready. On 25 September 2023, you, under the direction of Chewy, attend a location in Caulfield and exchanged 4.5 kilograms of MDMA for $260,000. You confirmed you had a total of $20,000 at your house. You confirmed at 6:30 p.m. that you were all done and you were on your way to Asian. Chewy told you to take $150,000 home and give Asian $110,000. You were told you needed to pass $150,000 to Chewy's friend the following day. On 26 September 2023, at the direction of Chewy, you dropped off $150,000 to an unknown person in Port Melbourne. And finally, on 27 September 2023, you were directed to attend South Yarra with $7,000 and then drive to Big Man's. You were told to take all the money, the remaining $3,000 plus the Big Man's, to take to Asian. And that concludes the factual basis for sentencing. Turning then to the regime that applies for sentencing for Commonwealth offences. Attempting to import border-controlled drugs is what's known as a federal offence. Section 16A of the Crimes Act 1914 provides that in determining the sentence to be passed or the order to be made in respect of any person for a federal offence, a court must impose a sentence or make an order that is of a severity appropriate in all the circumstances of the offence. In making this determination, Section 16A2 requires the court to take into account a broad range of matters, including but not limited to the nature and circumstances of the offence, any injury, loss or damage resulting from the offence, the degree to which the person has shown contrition for the offence, if the person has pleaded guilty to the charge, specific deterrence, general deterrence, adequate punishment, the character of the offender, including their mental and physical condition, the offender's prospects of rehabilitation, and the probable effect of the sentence on the offender's family. The legislature has not prescribed a hierarchy of sentencing considerations All of the matters set out in subsection 2 must be considered by the court to the extent they are known to the court, and I will address each in turn, starting with the nature and circumstances of the offence. This was a serious instance of what is an inherently grave criminal offence. The use of drugs, such as those you helped to import into Australia, causes untold damage to many lives. People who seek to profit from such misery are, when caught, invariably dealt with harshly by the law. You were engaged in a sophisticated importation scheme, and as you were paid a wage for your role, you engaged in the offending diligently as your form of employment. Any person who's so engaged is presumed to be doing so for profit. The quantities of attempted import of border-controlled drugs, that is charge 1, are significant, being 84.56 times the commercial quantity. The offending spanned a period of 9 days between 8 November 2023 and 16 November 2023. During this period of sustained engagement with importation activities, you applied considerable attention, effort and diligence to the task. Your offending falls comfortably in the mid-range of this type of offending. While you were not the principal architect of the scheme, you were a trusted operative. You made concerted efforts to engage in this conduct and were committed to the enterprise. Your moral culpability can therefore only be assessed as high. You provided a letter of apology to the court. In it, you express regret over the impact and burden of your offending on your family, friends and partner. You state that you've learnt the consequences of such offending and the impact that conduct such as yours can have on the people around you. You quite properly accept that actions speak louder than words. Your letter shows that you have some insight into the impact on those close to you. However, as noted earlier, drug offending has vast consequences for the wider community. You demonstrate little insight into the ripple and long-standing damage that importation and trafficking of drugs has on our society. As discussed further below, you've also demonstrated some remorse by way of your guilty pleas. Your cooperation with authorities, which is elaborated below, also illustrates some remorse for your offending conduct. Turning to your plea of guilty, a court will have regard to the timing of the plea, the strength of the prosecution case, and whether the plea at a late stage was a recognition of the inevitable rather than evidence of contrition or a real willingness to facilitate the course of justice. You've pleaded guilty to the charges at an early stage of the proceedings. Your pleas are indicative of a preparedness to accept responsibility for your conduct and evidences some remorse, and these matters are to your credit. It is important to recognise that your guilty plea has a significant utilitarian value as it saves the community the resources associated with your trial. It also saves witnesses the anxiety and inconvenience of giving evidence. In cases such as this, that is no small matter. The prosecution of large-scale drug importation and trafficking cases is notoriously complex and very expensive. Such cases take up vast amounts of court time, causing delays in the finalisation of other cases. By entering a plea of guilty, you've saved the resources associated with a trial. You are therefore entitled to an appreciable sentencing discount to reflect the utility associated with these savings. Turning to your cooperation with authorities. As noted earlier, you cooperated with the police investigation by voluntarily providing passcodes for your 2 mobile phones. It was by accessing 2 of those phones, a Pixel 5 and an Apple iPhone 14, that investigators identified significant drug trafficking between you and others using the encrypted Signal and Threema messaging applications. This evidence formed the basis of Charge 2 and the schedule offences of dealing in proceeds of crime and trafficking simpliciter. The prosecution quite properly conceded at your plea hearing that in these circumstances your cooperation was a significant matter of mitigation. The court raised with the parties whether it entitled you to a Doran discount on the basis that the prosecution would not have become aware of this further offending without knowing the passcodes to your phones. The parties were directed to file brief written submissions on the question. The prosecution submitted that your case does not enliven the Doran principle. It submitted that unlike Doran, where the offender contacted police to disclose offending, the disclosure by you of your passcode simply assisted authorities in accessing your phone in circumstances where police may well have accessed the data on the phone anyway. In these circumstances, the court must consider the likelihood of the authorities discovering the offending in another manner, On the facts of this case, it is likely that police would have discovered the offending, and therefore any sentencing discount should be modest and does not rise to the level of a Doran discount. Your counsel, on the other hand, submitted that you are entitled to a Doran discount, albeit one that is at a lower level than the discount that was given to the appellant in Doran itself. This is because the provision of the passcodes, in the knowledge that the phones contained valuable evidence for the authorities, was of very significant assistance. There is no evidence about whether police would have gained access to your phones in the absence of your cooperation. Your counsel submits that there are obvious policy reasons why courts should give significant sentencing discounts in such circumstances to encourage others to cooperate with police. In my view, regardless of whether the Doran label can be attached to your case, your counsel submits that your cooperation remains a significant mitigating factor. I accept the submission of the prosecution that your case is distinguishable from that of Doran, where, absent the cooperation of the offender, the police would not have had a case against him. Your case falls short of that level of assistance. However, I accept your counsel's submission and note authorities such as the case of Latina, which indicate that you are entitled to considerable leniency because of your admissions that were indispensable to proof of the magnitude of your offending. I accept your counsel's submissions that this discount must be greater than that which applies by virtue of your guilty plea. The reason for this is to encourage others to assist the authorities in similar circumstances. Turning to matters personal to you, as briefly mentioned at the commencement of my sentencing remarks, you're a young man well supported by your family and friends. I should just remark as an aside, I've never seen support like this in a sentencing hearing. You were born and raised in the western suburbs of Melbourne, living with both of your parents and two younger siblings. As a result of your parents' separation, your family experienced circumstances of financial hardship. The experience of these financial pressures fostered in you a deep concern about financial stability. You commenced work as a concreter very soon after completing Year 12 to help provide for yourself and your family, and you've continued to work in that capacity. You began recreational use of MDMA as a young adult. When you started to earn more money, your drug use increased in frequency and extended to other drugs, including cocaine. You were introduced to the drug syndicate by older work associates. They supplied you with drugs which you on-sold to your friends. I note in relation to your mental health that your counsel places no reliance on the Verdens principles. Turning to your prospects of rehabilitation, you were between 23 and 25 at the time of the offending, and as noted, you're now 27. Your counsel submits that your immaturity and failure to fully appreciate the nature and seriousness of your offending is evident in the phone messages. It is further submitted on your behalf that your relative youth remains an important consideration in the sentencing exercise. I accept these submissions. This submission reflects the law's well-established recognition of an offender's youth as a generally mitigatory force in sentencing. However, this general principle has less weight in sentencing for offending where general deterrence is a primary sentencing factor, such as the present. As the Court of Appeal in the case of As a Party observed, where the degree of criminality of the offences requires the sentencing objectives of deterrence, denunciation, just punishment and protection of the community to become more prominent in the sentencing calculus, the weight to be attached to youth is correspondingly reduced. As the level of seriousness of the criminality increases, there will be a corresponding reduction in the mitigating effects of the offender's youth. While your youth is of some relevance, I do not accept that yours is the type of offending where it can be said you have, whether because of your age or level of maturity, made an ill-considered or rash decision where the offending resulted from a lack of critical insight or self-control, or where you've not fully appreciated the consequences flowing from it. The court received some 16 character references from your family, friends and members of the community in support of you. I've read all of them. They can only be described as glowing. Recurrent themes in these letters are your expression of remorse, your deep regret and your acceptance of responsibility. You are a young man. You have your whole life ahead of you, and you are fortunate to have such an abundance of support from your family and wider community, all of whom have expressed a commitment to providing continued support upon your release from prison. The sheer amount of support demonstrated by your family and friends in their references, reinforced by their presence in court, speaks well of your future prospects of rehabilitation, in that you will be appropriately and adequately supported upon your release. Other positives are your lack of prior convictions, your work history, your lack of any mental health struggles, and the fact that you have used your time in prison to seek to further your rehabilitation, as evidenced by the certificates that have been provided to the court. On balance, I accept your counsel's submissions that your prospects of rehabilitation are excellent. Turning to other matters in mitigation, there's been some delay associated with your case. Although you were arrested and interviewed on the 16th of November 2023, you were not charged until 31 July 2024. A further 2 years have passed before you are to be sentenced. In accordance with well-established principles, the delay, none of which is your fault, is relevant in two ways. Firstly, other than one minor matter in September of 2023, you've not offended while on bail and have spent the time working hard and reconnecting with family and friends. Secondly, you've lived with the anxiety of knowing you will receive a lengthy period of imprisonment. So I didn't mean to suggest that you'd offended while on bail. Secondly, you've lived with the anxiety of knowing you will receive a lengthy period of imprisonment. Turning to current sentencing practices which a court is required to consider. The prosecution referred the court to a number of cases said to be comparable to yours. Most involved guilty pleas, 2 involved sentences imposed after trial, which can be put to one side. The attempted importation cases where sentence was imposed after a plea of guilty are the cases of Liu and the King, Lee and the King, and Obiekwe and the Queen. Sentences imposed were all around 12 years imprisonment. The 5 trafficking cases all involved sentences imposed after pleas of guilty. The sentences imposed ranged from 10 to 15 years imprisonment. Christie was a case where the offender trafficked in multiples of the large commercial quantity of several drugs on a single date. The offender had no prior convictions. The Court of Appeal increased the sentence from 12 years imprisonment to 15 years imprisonment, having found the sentence imposed by this court to be manifestly inadequate. In addition, your counsel referred the court to 3 importation cases and 1 trafficking case, each of which involved pleas of guilty. The first importation case upon which your counsel relied is Manila and the DPP. The offender's sentence of 11 years imprisonment on a federal charge of importation of a commercial quantity of a border-controlled drug was upheld on appeal. The offender was an integral facilitator of the importation in which her partner was the principal. The quantities of drugs were similar to this case. However, the sentence was to be served in what the Court of Appeal accepted were very lamentable conditions, and this entitled the offender to a significantly reduced sentence. The case is therefore to be distinguished. In the case of Cassia, the offender's sentence of 8 years imprisonment for aiding and abetting the importation of a commercial quantity of a border-controlled drug was increased on appeal to 10 years imprisonment. The quantity of drugs exceeded the quantity in this case by a considerable margin. The offender was found to have been instrumental in setting up the structure by which the importation occurred. The offender, who was in his late 20s, had no prior convictions and excellent prospects of rehabilitation. A sentence of 9 years imprisonment was reduced to 8 years in the case of Shakhanov. The quantities of drugs were similar to this case. The offender's role in the importation was relatively low level. He had shown remorse, he had no prior convictions and good prospects of rehabilitation. The limited use that a sentencing judge can make of previous cases was explained by the New South Wales Court of Appeal in the case of Cassia, and I quote, "It is important to bear in mind the limitation on the use that can be made of those cases and the purpose for which they can be used. As was pointed out by the High Court in the case of Hilly, comparable cases can be used to establish a range of sentences which have been imposed, but it does not necessarily mean that the range is the correct range. Rather, the cases provide a yardstick by which to examine a proposed sentence. Further, what is sought is consistency in the application of legal principle and not numerical equivalence. Within these limitations, I have been assisted by my consideration of the cases to which the court's been referred. Of course, your case must be sentenced on the basis of both its and your unique circumstances." As noted earlier, the prosecution has filed with the court 2 documents setting out other offences disclosed by the evidence which have not been the subject of charges against you. The court is asked to take them into account in sentencing you under Section 16BA of the Crimes Act and Section 100 of the Sentencing Act, respectively, and you've agreed that the court may do that. The correct approach that a sentencing court is to take, where the prosecution invokes these sections, was explained in relation to the equivalent New South Wales provision in the case of Attorney General's application under Section 37. The New South Wales Court of Criminal Appeal in that case explained that a sentencing judge takes into account the scheduled offences for which guilt has been admitted with a view to increasing the penalty that would otherwise be appropriate for the particular offence. This is done by giving greater weight to the need for personal deterrence and the community's entitlement to extract retribution for serious offences when there are other offences for which no punishment has in fact been imposed. The offences that the court must take into account in this sentencing exercise are far from trivial. The first, under the Crimes Act 1914, concerns dealing by you with in excess of $100,000 while believing the money was the proceeds of crime. It carries a maximum penalty of 20 years imprisonment. As noted earlier, between March and September 2023, you transported large sums of cash for the syndicate. The conduct was an integral part of the drug business with which you were associated. The total amount of money laundered by you was in excess of $820,000. This is obviously a very significant amount of money, and by your plea, you accept that you believed it was the proceeds of crime. While you are not to be sentenced separately for this offence, which as noted carries a maximum of 20 years imprisonment, the court must take this into account in sentencing you on charge 1. The amount of money makes clear that you are playing an instrumental and trusted role in the collection and distribution of the money derived from the sale of large quantities of trafficked drugs. The state offence to be taken into account concerns traffic of MDMA, contrary to Section 71AC of the Drugs, Poisons and Controlled Substances Act, the maximum penalty for which is 15 years imprisonment. You had your own drug trafficking enterprise in addition to the conduct you engaged in for the syndicate. However, I accept that the amount of MDA trafficked was relatively small. Turning then to the sentencing principles for the state offence of charge 2. It's a category 1 offence, therefore the court must impose a term of imprisonment other than one combined with a community correction order. The standard sentence for the offence of trafficking in a large commercial quantity is 16 years imprisonment. This is the period specified for an offence that is in the middle range of seriousness, taking into account only the objective factors affecting the relative seriousness of that offence. Those factors are to be determined without reference to matters personal to a particular offender and wholly by reference to the nature of the offending. The standard sentence, like the maximum penalty, is but one of a number of factors relevant to sentencing and does not affect the instinctive synthesis approach to sentencing. In sentencing you for the offence of large commercial quantity trafficking, I must explain how the sentence I impose relates to the standard sentence. I assess the objective gravity of your state offending as within that category of mid-level seriousness when considering only the objective circumstances. Those circumstances are: A, the charge is a rolled-up charge involving 4 different drugs, each of which you trafficked in a large commercial quantity. B, in total, the drugs trafficked exceeded 26 times the large commercial quantity of the various drugs. C, you were trafficking drugs on behalf of the syndicate over a period of 9 months, although your conduct was not consistent during that time. D, you were to receive a significant financial reward for your work and treated the offending as a job. And E, the role you performed in the trafficking enterprise was not at a low level. Although you were not the principal or architect, and while you were subordinate to others, you were not a mere low-level courier or functionary. You played a trusted role in the enterprise. Courts in Australia have repeatedly explained that a person convicted of large-scale drug offending must receive a long prison sentence, principally to deter others. For example, in the 2019 case of Kim, the Court of Appeal observed as follows: "We wish to make it clear once more that long prison sentences await those who participate in this pernicious trade. Those lengthy sentences are the occupational risk of the drug dealer, and with modern policing techniques, that risk becomes greater by the day. Should that risk become reality, the principles of general deterrence and denunciation will normally be accorded particular prominence in the sentencing mix. Those who choose to embark on the business of drug trafficking must understand that they will lose their liberty for an extended period. It is only in this way that the courts can discourage those lured by greed into an enterprise that is so harmful to our community." The need to achieve general deterrence and to protect the community mean that matters personal to an offender, such as their youth and prospects of rehabilitation, are given less weight in the sentencing synthesis than will normally be the case. Before I pronounce the orders in this case, I note the relevant sentencing purposes in this case are general and specific deterrence, punishment and protection of the community. Against those matters, and to the extent that I am able to, I must balance your future rehabilitation because of your age and what I consider to be your excellent future prospects. Could you please stand, Mr. Willet? Taking into account the maximum penalty, the seriousness of your offending, the plea of guilty, your personal circumstances and the other matters in mitigation discussed above, the Court makes the following orders. Starting with Charge 2, the state offence of trafficking in a large commercial quantity of drugs of dependence, you are convicted and sentenced to 12 years imprisonment. You must serve 7 years and 9 months before you're eligible for parole. That's the state non-parole period. And the state sentence commences today. On Charge 1, the federal offence of attempting to import a commercial quantity of a border-controlled drug, you are convicted and sentenced to 13 years imprisonment. You must serve 45 months before you are eligible for parole. That's the Commonwealth non-parole period. The Commonwealth sentence will commence on the 3rd of July 2030. The sentences have to be structured in that way because of the complexities of sentencing law. The bottom line is that the total effective sentence, that is state and Commonwealth, will be 17 years and the non-parole period will be 11 years and 6 months. The sentence imposed in respect of Charge 2 is less than the standard sentence of 16 years, having regard to the objective gravity, your early guilty plea and the other matters of mitigation discussed earlier in these reasons. Ms Baxter, can I just confirm the pre-sentence detention?
47 days, Your Honour.
That's an agreed number,
That's
isn't it?
agreed, Your Honour.
Thank you. Not including today.
Not including today.
Thank you. Pursuant to Section 18 of the Sentencing Act 1991, I declare that you've served 47 days in custody, not including today, which is to be reckoned as time served in respect of the sentence that the Court imposes today. Pursuant to Section 6AAA of the Sentencing Act, but for the plea of guilty, in other words, if you'd contested these charges and been found guilty by a jury, you would have been sentenced to 22 years imprisonment. The non-parole period would have been 16 years.